Estate planning is essential for every family, but especially for LGBTQ plus people and their families. There are specific steps you can take to protect yourself, your family, and your assets. In this video, we cover what LGBTQ couples can do to plan for themselves and their family, the specific steps that can be taken, from non-biological parental rights to medical decision-making, property ownership, and inheritance. Whether you're legally married, in a committed relationship, in a domestic partnership, or raising kids with a chosen family, our guide is here to help you make a plan that will work for you. We want to make sure you feel confident and informed. So book a free 15-minute consultation with my office so we can talk more about your specific situation and how we can help you. California law provides protection for married couples and registered domestic partnerships, but no protection for unmarried partnerships. That is why it's so important to take care of your estate plan and be proactive to ensure that the wishes that you want are carried out with the people who you have chosen to carry those wishes out. Unmarried partners will need a will, a power of attorney, an advance healthcare directive, in addition to other documents that may become relevant in order to protect themselves and protect their family and ensure that their wishes are carried out. Some key considerations. First of all, are there kids? If there are no children, it can be even more important to do proactive estate planning. Most often, couples want to provide for each other and leave their assets to care for their surviving partner or spouse. But many times, you don't necessarily want those assets to go to the family members of that partner. You would prefer to have those assets boomerang back to your heirs, nieces, nephews, or siblings. You can ensure this is taken care of by properly setting up your estate plan. You also want to ensure that there are remarriage protections so that your assets do not go sideways in the event that the surviving spouse or partner remarries. You may want to ensure that those assets do not go to that future spouse of the survivor and to their family or their children. If there are kids, are the children biological, and of who? Is there proper adoption paperwork to ensure that the surviving parent has all the rights and abilities to take care of their child and be able to protect them? Not only ensuring that the other parent has secured proper, full, and legal adoption rights, but also ensuring that any parental rights of a sperm donor were effectively severed in a legal manner to ensure that any other biological children of that sperm donor or the donor themselves cannot make any claims on the estate that you want to make sure goes to support your children. There are also many legal and tax issues that need to be considered when you're deciding whether you want to enter into a legal marriage, a registered domestic partnership, or just remain as partners and companions without all of the legal structure that goes around it. In California, we don't have any issues around the legality of marriage, the legality of domestic partnership. More likely, the main considerations are the tax and legal implications that come with marriage or a registered domestic partnership. Many people do not realize that unlimited gifting is allowed between spouses and unlimited marital deduction is available between married people after the first spouse passes away. This means that if your spouse passes away and has unused tax exemptions at the federal level, those can be ported over to the surviving spouse. Right now, The federal estate inheritance limit is 13.99 million per person. If that is unused during the lifetime of the spouse, when they pass away, it can be ported over to the surviving spouse along with all of the assets for a total of close to $28 million that the surviving spouse can take advantage of to ensure that there are no estate taxes whatsoever. Because in California, there are no state inheritance taxes. There are only the federal inheritance taxes. Some pros and cons of legal marriage or domestic partnership. So when it comes to taxes, you can file jointly, which can often have tax advantages to reduce your overall tax burden. In addition, there are tax credits for children, tax credits for employer-related health benefits, again, portability for that lifetime gift tax exemption that can only be utilized by married couples or those in a qualified domestic partnership. Capital gains tax exclusion is $250,000 for an individual, but for a married couple, that's $500,000 that is excluded from capital gains tax. The Garn-St. Germain Act basically makes it so that if you are on a mortgage and you pass away, it does not trigger the due on sale clause that is often in most loans for your spouse, and they would be able to continue the existing mortgage. Married couples are also eligible for Social Security benefits, veterans benefits, military personnel benefits, and federal government employee benefits, which would not otherwise be available to unmarried partners. Finally, private pensions are often only payable to a spouse and no other beneficiaries. That can be a really good reason to make sure that you have a legal marriage in place to ensure that all of the value of the pension is captured by the surviving spouse in the event that you pass away. Finally, with immigration, green cards are now available for same-sex spouses for the non-citizen spouse. So those are some tax considerations and some benefit considerations. Cons to marriage. So depending on your income and assets, filing jointly can have a negative effect on your tax situation and how much you end up paying in taxes, especially for very high net worth earners. There's something called a marriage penalty that can really impact joint filing. There's a limit on your home mortgage deduction of $1 million, regardless if you're single or married. Bankruptcy by one spouse can negatively impact the credit of the entire household when you're a married couple or in a domestic partnership. Married couples can be liable for each other's debt, depending on how the debt was taken and the nature of the debt. Spouse income can affect eligibility for financial aid or student loans. And then family attribution of political contributions. When you may have differing views on politics and one of you wants to contribute to a politician or a political party that you do not agree with, if you're married, your family name will be attributed to that contribution. So overall, really this is about privacy. It's about ensuring that everything is kept private, that the courts and the government are not involved. So that's why we recommend that you do proactive estate planning to ensure that the court would never be involved in the disposition of your assets and having any say about who is getting your money or who is in charge of your estate. Because when the court is involved, if you do not have a will and trust that designates who your heirs are and who's in charge, they're going to follow the law, which basically gives the automatic right to your family members to have the ability to have the authority over your accounts, and then your family members would be the legal heirs to receive your assets, and that may not be what you want. So that's why it's so important to be proactive about your estate planning. It also gives you the advantage of protecting assets from creditors. You have a lot more leverage in the administration of the estate when it does not go through the court process. It allows you to support charitable causes, things that you care about, and it ensures that your wishes are clearly documented in legal documents that would hold up in court, that your family could not contest if it's counter to their beliefs or what they think should happen to your estate. So take action. It's time to protect yourself, protect your family, and especially for those of us in the community who are in same-sex partnerships, and especially if you're not married and you don't have a domestic partnership. We are happy to talk to you about this, so please give us a call, schedule a free 15-minute consultation. You can also sign up for one of our free monthly workshops or watch our on-demand webinar so you can learn more about the basics of estate planning, how it applies to you, and why you might want to come see me and get your estate plan all squared away. Please like and subscribe at the link below. We'd love to have you follow our content. We will continue to provide interesting, helpful, and informative information that will only benefit you in the long run. So we look forward to seeing you again here. Bye.